Okay, so it looks like we have some people joining us. Thank you all so much. I really appreciate it. Thank you for, coming to our Legacy Giving webinar today. I see a lot of familiar names on the call, but for those of you who don't know me, my name is Isabel Slater, and I'm the Major Gifts Officer for Animal Protection of New Mexico and Animal Protection Voters. I just wanted to go over a few technical things with you right up front about today's call. You will see on the bottom of your screen a chat function. You can use that to chat with other attendees or with the panelists. We would love it if you could join. We also have for this option a Q&A portion, which you will also be able to find on the bottom of your screen. The last 15 or 10 minutes or so of this presentation, we will answer questions. You can submit them at any point during the presentation and we'll answer them at the end using the Q&A option. So all you do is click on that. You should be able to submit a question, and then you'll be able to see your questions along with other questions that people have submitted, and you can even like them and they'll get higher up on the list if you would like, or if someone has already asked the question that you would like to ask. So I would also like to introduce our wonderful panelists today. First, we have Vicki Wilcox. Vicki is an attorney practicing in the areas of estate planning, tax law, probate, estate and trust administration, charitable giving, business planning, and business succession planning. Thank you so much for joining us, Vicki. We're really lucky to have you here today. Would you like to say anything about your work?
No, thank you for the introduction. I guess I would mention that I also have attorney Madison Jones here who's helping me, and she may occasionally add to the presentation or assist with the PowerPoint as well. Thank you, though.
Wonderful, that's great. I also wanted to introduce our other fantastic panelist, Mark Napolin. Mark is a financial advisor with extensive background in all aspects of financial consulting. We're so lucky to have you on as well, Mark. And would you like to say anything else about your work?
No, I just wanted to say that I'm a big fan of Animal Protection New Mexico, and I'm very, very happy to share my information with the audience.
Wonderful. Well, we're super lucky to have you both. And thank you for sharing your expertise with our supporters. So with that, I think I will turn it over to Vicki to start her presentation.
Great, thank you. I'm going to put the PowerPoint on. Okay, great, thank you. So, of course, we have to start with the legalese and say that this is just a general presentation. And if anyone who's listening has any specific questions that they have for their own estate planning, they should talk to their own advisor. That'd be your CPA, your attorney, your financial advisor. Feel free to ask us for general advice, but for specific information, talk to your own advisors. Okay. So I always like to start these presentations by asking people, what's new? What's motivating each of the people in the audience to consider their estate plan right now? And it's fascinating to me because you can definitely see trends at different points in time. In the past, we've had a lot of people become interested in estate planning because of tax law changes. Recently in New Mexico, people were interested in estate planning because of some articles in the newspaper in Albuquerque about guardians. They were investigative reports called Who Guards the Guardians? And they were kind of scary, and it motivated a lot of people to have their own estate planning reviewed and updated. But recently, what we found when we ask people this question, like what's new, what's making you consider your estate plan? Of course, it's COVID. And so when we dig a little bit deeper and ask, what about COVID is making you think about estate planning? First answer is health. They want to be sure that they have their healthcare documents in place so that if they're in the hospital, their family members can contact the doctors, ask questions. They want to make sure that they have named somebody to advocate for them if they can't speak for themselves, if they're on a respirator. But also during this COVID period, people are having more time on their hands, and they're using that time, I think, to reflect on their wishes, their testamentary goals, what they want their legacy to really be. A third reason why COVID has really sparked a lot of interest, I think, in estate planning is one that's personal to me as well. And that's because a lot of us have adopted pets. We have the COVID pet. This is Houdini. He's our dog. And during the stay-at-home period that was really strict, someone dropped Houdini off in our yard. And before then, we were cat people. We weren't really dog people, but he won us over. You can see he's a cutie patootie. That's a technical term too. But he really won our hearts. And I'm sure with a lot of other people, all of a sudden you have this real intense connection and bond with your pet that you might have had before, but it might be even stronger now. And you want to make sure that you can provide for them. So that's part of what we're going to talk about today. Really, I'm going to hit on 3 primary sections. First, how can you provide for your pet? What can I do for Houdini to make sure that if I'm disabled or if I pass away, he's going to be cared for? Second, how can you provide for animal welfare in general? And third, how can you provide for yourself? We mentioned those healthcare documents. What can you do to make sure that you're more protected if an emergency comes up? So those are the 3 primary areas. We're going to move now to the first one. How do you provide for your pets? People are often surprised and sometimes a little sad when we tell them that their pets are considered personal effects, their property. And so the easiest way to make sure that your Houdini or your cat or your horse, whatever your pet might be, passes on to the person that you think would be a good caregiver at your death is to identify that pet and the caregiver on a personal effects list. A personal effects list is authorized under New Mexico law. And I know one of the questions that we had beforehand is how specific is this presentation to New Mexico law? Generally speaking, most of the things we're talking about today are probably the same in different states. But again, you're going to want to talk to your particular attorney and ask him or her whether or not a personal effects list is authorized in your state. Most states do have that because it's convenient. It allows you to identify who's going to receive your jewelry, your furniture, your tangible items, but not money. You can't leave your pet and money on a personal effects list. So to recap, that's a companion document to a will. It does not usually have to be notarized. It's very simple. And you identify the person who will receive an item, including a pet, and the item itself. So that's the easiest. And usually it's pretty clear. Rarely do we see that contested with pets. We do see it contested if, grandma has promised her ring to 3 different grandchildren. That can be a problem. But generally with pets, if you're clear, it's a pretty easy way to make sure that your pet will pass to the person you want. Second idea is to actually leave provisions in your will or your trust, whichever is your main testamentary document. And if you do that, you can also provide for money to take care of your pets. This is very important, for example, with horses. As you probably know, horses can tend to be expensive. The vet expenses can quickly become more than the person anticipated. And so if you want to identify a caregiver and the pet that will pass to the caregiver and some funds to help provide for the care, you might think about something more complicated than the personal effects list, but more protective. And that would be a specific instruction in a will or a trust. If you are providing for a substantial amount of assets to be set aside to provide for your pet, then there's actually something that can be put in place called a pet trust. And think of Leona Helmsley. She's like the classic example where she had that cute little puppy, and at her death, she left her estate for the care of her dog. Well, that's a great example too, because it illustrates one of the problems. You want to be sure that it's a reasonable amount. So in Leona Helmsley's case, the court actually reduced the amount of assets that she was leaving to her pet. New Mexico law also requires a reasonable amount. Now, sometimes we have people come to us and they love the idea of a pet trust because it's protected. You're going to make sure that those assets are only used for Houdini. Or Mark, what's the name of your dog? Jack. Or Jack. Mark's Mark's pet is Jack. So you can provide specific instructions and restrictions, but the problem is sometimes it can be administratively too complex, too expensive, too complicated. Forgive me for using this phrase, but it can be something equivalent to putting a saddle on a cat. That is a legal phrase. So it's a discussion that you want to have with your attorney and your family and your financial advisor, and really find which of those vehicles best fits your situation. And it's going to depend on how many pets you have, how old they are. You know, if all of your pets are at the end of their life, you're probably not going to leave $1 million for their care. And if you only have one pet, you're probably going to leave less than if you have 5 horses. And then also how much you're willing to invest in the administrative costs, the legal fees, the execution of those different options. So really, in a nutshell, those are the primary ways that we advise people to leave instructions for their pets. I didn't mention on the slide, but one thing I should mention is that if you become incapacitated, it's important to have a good power of attorney in place where you've named somebody to step in your shoes and handle your financial matters if you become incapacitated. And so that would allow the person to change the locks on your house if you were in a car accident and you were not going to be able to visit your house for a couple months. They could then also take care of your pets or find a new home temporarily or permanently for your animals. So caring for a pet during disability is probably best achieved by having a power of attorney in place. Make sure that you update it at least every 3 years. And we're going to talk about powers of attorney in a little bit, but that's an important document. Okay, so next slide. Providing for the animal population in general, you can make donations to charities directly supporting animal welfare. You can make them during your lifetime or at death, of course. And one of my favorite ways to make a charitable bequest is through an IRA beneficiary designation. And I know that Mark is going to talk about that more later, but those are all really good options. During your lifetime, of course, that's just a direct transfer. We're going to talk about a couple unique ways you can handle a gift of real estate. But at your death, generally, it's either through a bequest that you outline in your will or your trust, or a beneficiary designation on a life insurance policy, a transfer on death deed where you're leaving real estate, or a beneficiary designation on a retirement account. Those are the primary ways. So let's talk about real estate. Gifting land. My word of caution to all of you is if you're thinking about transferring property to a charity, it can be a very generous gift and it's wonderful of you to think about it, but please talk to the charity first, because a lot of times charities aren't equipped to handle the gift that you've made to them. Sometimes they don't want property. For example, maybe you have a piece of land that in a previous time period was a gas station. All of a sudden, they're burdened with some property that has environmental issues, and you can actually be giving them a burden instead of benefiting them by that transfer. Timeshares are a classic example of a problem asset that charities are usually pretty reluctant to accept. We'll meet with clients and ask them about their assets, and they'll have timeshares, and all of a sudden it's a big red flag, because in order to transfer a timeshare to a trust, you have to make sure that you know the governing law is considered real estate. And so sometimes clients will have to hire an attorney in a different state. And their response is, well, I'll just give it away. Well, the same reason you probably don't want to keep it long-term is a reason why the charity or even your child might not want that timeshare. There's monthly fees. You can end up paying more than you ever anticipated with the timeshare. So please don't assume that just because you want to give something to a charity that they want to receive it. We have this happen frequently as a side note with art. People have art that they've collected and they think it's a fantastic collection, and it probably is. But the museums right now are so overwhelmed with donations of fantastic pieces that they just can't accept them all. And so we encourage clients, before you, on your personal effects list, designate a museum to receive certain pieces, please check with the museum and make sure that they actually will accept that painting that you have. So it's the same with land. But let's say, for example, you have a piece of land and you want to give it to a charity. If you have a will or a trust, the easiest way to do it is simply in your will or your trust to say that at your death, that piece of land will be distributed to XYZ charity. Stop though and think, would it be better to give them the piece of land, or would it be better to have the fiduciary, the trustee, or the personal representative sell it for them and then give them the proceeds from the sale? And by doing that, you're not burdening the charity that's already scrambling, under a limited budget. You're not burdening them necessarily with going through your personal effects and dealing with the mortgage and getting the inspections done, but you're still benefiting them with the proceeds from the sale of the property. So again, will or trust, direct bequest. A transfer on death deed, this is something that's unique to each state. Some states have it, some states don't. More and more states are adopting it. What a transfer on death deed is a deed that is completely revocable. You can change it whenever you want, but if you don't change it at your death, the deed says that your piece of real estate will pass to the beneficiary that you designate, and it will not go through probate. So you don't have to have a trust, and you don't even have to have a will. You can just have this transfer on death deed that specifies your wish at your death. The property will pass to the charity or the person that you've designated. That can be a very smooth way to transfer property. Again, talk to your attorney though, your financial advisor, your CPA, especially if you have a mortgage on that property, because there can be some problems if your mortgage is a debt of your estate and you're transferring the underlying real estate to someone else. You want to make sure that all those issues are coordinated well. A limited liability company, this is something that we discuss with clients regularly when they have property that they want to transfer to a charity and the charity does want to accept it. Maybe it's a house that they're going to use for visiting artists, or they want to keep it and maybe they're going to have a second office in it. There's lots of different reasons. But if you're worried about environmental issues or any type of taint on that property, you can use a limited liability company. So what that means is that you, during your lifetime, would take the real estate and transfer it to a limited liability company that you form, you set up, and then either during your lifetime or at death, you give the membership interest, the ownership in that LLC to the designated charity. And by doing that, you're helping the charity quite a bit in insulating itself from any type of claim regarding the ownership of that asset, like environmental issues and other things that could pop up. Life estate is another option. This is where some people will say, I want to give my house to a charity, but I need to live in it until I pass away. What do I do? You can actually, in most states, transfer property to the charity now and maintain for yourself a life estate. I'm not a huge fan of these because I worry about all of the problems that could pop up. If you are going to do it, you want to have a pretty robust, fleshed out agreement with the charity that covers such things as repairs. How are you going to decide if it's a nominal repair that you as the life estate holder should cover and pay for, or if it's a more substantial repair that the charity should be responsible for? What if you become incapacitated and don't maintain the property and the value's going down? Does the charity have the right to inspect the property? There's lots of different issues, and you want to be sure that you try to anticipate and address those issues and at least have some type of mechanism for discussing unanticipated issues that might pop up too. But that is another option, and I know some people take advantage of it. The charitable remainder trust is very popular right now. Mark's going to talk more about it, but it's in a very quick nutshell, it's a vehicle to transfer low basis assets, like a commercial building that you might have depreciated, to a trust, sell the asset, and then get an income stream for your life and not have to recognize all of the income tax at once. And again, Mark's going to talk more about that, but that can be another way to transfer the benefit of the real estate to the charity eventually when you die. So the assets that remain in it would pass to the charity. Again, be cautious of timeshares, and please talk to the charity before you make a gift of something like real estate to make sure that it's an asset that they would appreciate and would be willing to accept. Okay, so that's providing for animals in general. Let's talk a little bit about providing for you. These are the documents that we consider part of a basic and solid estate plan. So the first document, of course, is either a will or a trust. And years ago, people would come to us and they would say, what do I need, a will or a trust? And it was easy because it was driven by the size of their estate. This is back when the credit amount was much lower. Credit amount means the amount that you could pass estate tax free. It used to be much lower than it is now, and so it was driven by estate tax issues. Right now, under current law, if we were live, I would ask you all to raise your hand. I would ask you if you knew how much you could pass estate tax free to your children at your death under current law. And most people have guesses, but they're usually way off. Right now, it's 11.58 million. So most of us don't have that problem. So you and your spouse could have 22 million without an estate tax. So some people still are looking at estate tax savings to drive their estate plan, but most people aren't. But there are other considerations. How concerned are you about protecting assets for your beneficiaries? Do you have a spendthrift in the family? Do you have a special needs grandchild? Are you putting in place a pet trust? Those issues will help determine whether or not a will or a trust might be more appropriate. Do you have out-of-state property? That's usually a trigger for using a trust rather than a will. But again, those are issues that you should talk with your own attorney about and try to work through that process. I feel bad for young estate planning attorneys because it's a much harder analysis now than it used to be back in the day when the credit amount was $650,000. I think that's what it was when I started. Yeah, it was low. Financial power of attorney, one of the most important documents you can have to protect yourself and keep yourself out of court. We recommend a statutory power of attorney. Well over half of the states in the country have adopted the same form. It's a statutory form. Because it's so popular, many third parties recognize it and accept it without sending it back to their legal department. So that document really is a more effective document than a beautifully written 20-page document that your attorney might have drafted for you. This poorly written, in my opinion, statutory power of attorney is going to do more for you than the beautifully written 20-page one will. The other thing to remember is that you should update your power of attorney every 3 years. That's not what the law says, but that's the standard of practice. After 3 years, third parties are reluctant to accept it. So you really want to keep updating it, even if you have no changes. Healthcare power of attorney is a document that names the person who can act for you and advocate for you if you can't speak for yourself with respect to your healthcare. People will always ask whether or not they should name their oldest child, or does it matter if somebody's out of state? My opinion is that what's important is that you can find somebody who knows what your wishes are and who will respect your wishes and who will advocate for you. So that person really might have to go toe-to-toe with the hospital to argue that you should be taken off of life support or should be kept on life support, really to reflect your wishes. The living will is a document that says that if you are terminally ill and there's no hope for recovery, you do not want to be kept on life support. We recommend that you allow your healthcare agent to override the doctor's decision. So if two physicians say you're certain to die in the immediate future, but your healthcare agent wants to have a third opinion or wants to wait another week, your healthcare agent should be able to do that, in our opinion. The HIPAA waiver has become so important, especially now with COVID, where we're finding access to the hospital and to the patient is becoming very restricted. New Mexico today just issued some new restrictions where only in certain circumstances will visitors be allowed in the hospital. The HIPAA waiver will allow the medical provider to talk to your loved ones, your family, your friends that you've granted permission to if they call the hospital and ask about you. So generally we explain it as a collective group of people who can ask for information but not make decisions. So sometimes people will say, I want my mom on there, but I don't want her deciding anything for me because it would be too difficult. That's where the HIPAA waiver comes in. It gives her access, not decision-making authority. Word of caution on these documents, make sure you have access to them. So if you have a healthcare power of attorney and a HIPAA waiver, make sure that somehow somebody can get them to the hospital if you're in there unexpectedly. In our office, we provide our clients with a laminated card that tells the reader to call us for copies of the documents. You could do something similar and write in your wallet a note saying, call my son or call my daughter at this number for copies of these documents, or check my glove compartment. Sometimes people do that. Postmortem directive, that's where you identify your wishes after you pass away. Do you want to have your remains buried? Do you want them cremated? Green burials becoming very popular lately. Whatever your wishes are, you can express them in that postmortem directive. And we talked about the personal effects list. And I think I am almost exactly on time to transfer over to Mark. Thank you all.
Thank you so much, Vicki. That was amazing.
Thank you.
Thanks, Vicki. That was great. I took some notes for myself, even though I recently updated my estate plan with a mutual friend of ours. I did not get a little plastic laminated card. I'm gonna have to make a major complaint to her. So thank you, Vicki. I'm gonna go ahead and screen share, Isabel.
Wonderful.
Okay. Can everybody see that all right?
Yep, we can see your screen.
Okay, good. Well, before we get started, I wanted to just say a couple of things. I made some notes while Vicki was talking. You know, these are very stressful times. We did a presentation for our clients twice during the COVID pandemic it was titled The Emotional Pandemic, and Dr. Gail Feldman was the leader. She also spoke on collective trauma that we're all experiencing, not just over COVID, but think about this, hurricanes. We've had, I'm gonna start my timer, pardon me just a sec. We've had hurricanes, we've had fires in California, we've had massive unemployment. We have families that cannot take care of themselves with just the basic necessities of life. So this collective trauma is really affecting us all. And what I did want to say to you all, as a financial advisor, as a person dealing with your life savings and your legacy, I would say an important thing right now is to not make emotional decisions about your money. Not make emotional decisions regarding your estate plan. If you get on that emotional roller coaster, you are bound to make bad decisions regarding your financial matters. We're also, you know, many of our clients are either close to retirement age or nearing retirement age or actually in retirement. And they're very concerned about what's going to happen over the next 2-3 weeks, 4 or 5 months. Who knows? Because we've got, you know, the uncertain outcome of COVID, the uncertain outcome of the elections. For most people, we believe it's sensible now to reduce risk, at least during this period of time, and then perhaps go back to your investment strategies after things settle down. Now, there could be tax consequences in doing that, so I would definitely say to check with your financial advisor, with your accountant, regarding reposturing your portfolio. My dog Jack happens to be asleep on the floor now, and let me just look over at him. He's kind of photogenic, but he's parked himself near the trash can, so I won't show him to you. But he's a great guy. He's my constant companion, and I found his adoption papers the other day from Animal Humane. It was 9 years ago that I adopted him, and they said he was 1 year old at the time. So I've got a senior citizen dog, and he's a pretty sprightly guy though. The next slide is a letter that Animal Protection New Mexico and Animal Protection Voters uses, where you can give, it's a very simple piece where you can give your legacy intent to APNM or APV. And I'm going to be talking about all of those areas. And the first one, Vicki already talked about, an outright bequest in your will. The second one would be a gift of a life insurance policy. The third, a gift of stock or other appreciated property. And when she says they're property, it must be accepted by the intended beneficiary, meaning that if it's a piece of real estate, it has to go through committee at Animal Protection New Mexico or APV to make sure it's an acceptable piece of property. The amount of the gift, optional, and then if you put additional notes or restrictions on that gift. So this is a pretty simple form, and of course you can give much more detailed instructions. I'll cover most of these in my presentation. Vicki talked a little bit about beneficiary designations. I've listed 3 areas where you can make it very simple, like on your IRA or retirement plans. You can simply name APNM or APV as a beneficiary in full or part, or name them as a secondary beneficiary. So IRAs and retirement plans, when they are received by your beneficiaries, it is subject to income taxes. So if you had a $100,000 IRA and you give it to your daughter, as she takes money from that IRA, she'll pay income taxes on it at her tax rate. So depending upon the tax rate of your kids or whoever those beneficiaries are, if it goes to a spouse can just keep that in her name or his name and not recognize the income taxes right away. But for a child, they would definitely pay income taxes on it as they take money out. Life insurance policies, many of you have policies maybe you've had for years that when you were raising kids or paying off mortgages, you had those policies and now they've served their useful purpose. You can simply name Animal Protection as a beneficiary in full or part. So let's say you had a $100,000 insurance policy. You might want to name Animal Protection for 50,000 of it, and then maybe your spouse or your kids for the other 50,000. And you can do it with personal policies or group insurance policies. So if you work at, let's say, Sandia Labs, and you've got a couple $100,000 of life insurance through work, you can designate a beneficiary on that as well. The same with annuities. Many people have annuities that are not in a retirement plan, but they're just held in the annuitant's name. In other words, the owner of it is you, and you could name Animal Protection as a beneficiary, again, in full or part, or even as a secondary beneficiary. So first beneficiary might be your spouse, secondary beneficiary could be Animal Protection. Annuities are also taxed to your beneficiaries. So whatever the gain is in the annuity is taxed. In this way, it avoids the income tax. And the important thing here, they provide an immediate benefit to APNM. Some of these I've seen settled in a week to 10 days, but certainly within 30 to 45 days at the longest. And again, if you have questions, please pop them up for us and we'll be happy to answer them for you. This is a big one. It came out a few years ago, and we've had some clients do it very successfully, as easy as can be. When you are taking distributions from your IRA, which are those required distributions that you must take each year, you have to be at least age 70 and a half to do this. But you can take all or part of your required minimum distribution, which is, it's taxable to you in your tax bracket. So let's just say you were living on Social Security and maybe a small pension, and your regular income from Social Security and your small pensions, let's just say it was $50,000 a year. But now you had an extra $50,000 that was coming to you from your retirement plan, which could be coming from an IRA that you've rolled over or whatever. And those are mandatory distributions. Well, that's going to add to your taxable income. And so what you might consider doing then is using that required distribution, all or in part, to go directly to APNM. So essentially, the IRA trustee, it could be a bank custodian, it could be a brokerage firm as custodian, it could actually be a trust company as custodian of your IRA. There's going to be a custodian, and it could be just held by the mutual fund company. That transfer has to be made directly to APNM. So you can't touch it. And also inherited IRAs. So in my dad's case, for example, my dad passed away at 94, and he left me my brother, my sister, and I an IRA, which we're taking lifetime distributions on. My brother and sister and I, if we're age 70 and a half, we can use those to make our distributions directly to APNM. The distribution is not included in your taxable income, so therefore it helps reduce your taxable Social Security benefits. As you know, there's Social Security benefits have taxation on them. If your income hits a certain level, you pay a higher tax on your Social Security benefits. So it can help reduce your income for those purposes. And many of you are if you're retired, you might be paying a Medicare surtax, which is based on your income. And so therefore, by making this distribution through the qualified charitable distribution, it does not add to your income for Medicare purposes. And also, because you could be in a lower tax bracket, it will reduce the taxes on any capital gains and dividends that you receive. Another point there is Secure Act the Secure Act came out 2019. It allows people who are beyond age 70 and a half, if they have wages, they can still make contributions to their IRAs. So you're making contributions to your IRAs. Now you can use those funds. There's some restrictions on it, but you can use those funds to make charitable gifts. I'm thinking of a recent one. The gentleman is a retired attorney from a major law firm. He had their 401k for many, many years, and he rolled it over into an IRA. He had been making checks out every year to Cornell University, which gave him his start in life and as a lawyer, and he feels a very strong tie to them. He'd been giving $2,500 a year for many years, and the last couple of years, he's used $2,500 of his required distribution to make that gift. It's worked out beautifully for him. And a nice thing, if you're not an itemizer, and remember under the new tax law, if you're not an itemizer, you get a $12,500 exemption amount. And if you're married, it's about $25,000. So many people these days are not in a position where they're itemizing. So therefore, they're not getting any tax benefit from making a contribution to their charities. So let's follow this for a minute. Let's suppose you're getting $10,000 a year from your IRA as a required distribution. You could direct those funds to APNM or your other charities, and you won't pay taxes on them. It's almost like it's a deduction, but it never crosses your taxable income. It's a beautiful idea. And Vicki and I can answer questions on these if you bring them up into the chat. The donor advised fund is a very, very popular way. You've heard about private foundations that are established, like Bill and Melinda Gates, other major foundations, the Ford Foundation, the Javits Foundation. There's, very, very wealthy people have put their assets when they've passed away into these private foundations. Vicki and I feel that they're not appropriate for most people because you've got to set up the trust document, all the agreements for the private foundation. You've got to file an annual tax return, and there's a lot of rules and regs to follow. But a donor advised fund allows you to make gifts of cash, securities, even real estate to a donor advised fund. The donor advised fund is managed by some of the larger investment firms. For example, you could set one up with Schwab or Fidelity. Our firm handles them as well. Or better yet, you can go to your local community foundation, and Animal Protection New Mexico has funds at the Albuquerque Community Foundation, Santa Fe Community Foundation, and the New Mexico Community Foundation. So let's just give an example. Let's suppose you had $100,000 of appreciated property and you donated that to your own donor advised fund. It could be the Jeff and Vicki Donor Advised Fund at the Albuquerque Community Foundation as an example. Jeff and Vicki would receive an immediate tax deduction for that gift to the donor advised fund. And the assets in that fund grow tax-free. Each year, let's suppose that Jeff and Vicki had said, we want our funds to be for animal welfare in all categories. And so therefore, each year they could make their gift from that donor advised fund. They would tell the community foundation, I want $2,000 to go to APNM, and I might want $2,000 to go to Animal Humane. If Vicki and Jeff passed away, or when Jeff and Vicki pass away, the donor advised fund has an indefinite lifespan. So the donors, Jeff and Vicki, could appoint a successor. They could ask Madison to advise those funds after their death and seek out and follow their desires. So if, for example, the charity that they were supporting no longer existed, or the donor advisor felt that it was not really meeting the criteria any longer for receiving the gift, they can use another animal welfare organization for that support. Again, a great concept. I know there's a question coming up that Isabel told us about in advance, where this could be a perfect vehicle to make some planned gifts when you're a younger person as well. Looks like I have about 10 minutes left. The charitable trust, I don't want to get into a lot of details on it, but we're talking about in this example a gift of real estate. And Vicki ran some numbers for me on a $1 million property that's been appreciated. That doesn't have to be $1 million property. It could be a $50,000 property. It doesn't even have to be real estate. It could be stocks, it could be bonds, it could be other assets that got appreciated in value. So let's suppose it's a piece of real estate. You essentially you create the trust, which is called a remainder trust or a CRT. You transfer that property to the charitable remainder trust. So now the real estate is not owned by you, it's owned by the CRT. If it was real estate and APNM accepted it, they would most likely sell that real estate on the open market for the best price possible, and all those sales proceeds would then be invested in your trust. The donors, let's suppose it's husband and wife, or mother and father, whoever it is, brother, sister, the donors can be the trustees. Some people choose a corporate trustee, but you could actually be the trustee. On this $1 million example, the trust will pay the donor a minimum of $5,000 per year, or excuse me, 5% or $50,000 per year. And if the trust is growing in value over years due to good investment returns, it could actually be greater. Critically important here is that the donor avoids the immediate capital gains tax on the appreciation. And if it was a property that had been depreciated over the years, you don't suffer the recapture of that depreciation. Nicely up front, there's a tax deduction in this example for a couple who's age 65. There's a $334,000 immediate tax deduction, and you save the capital gains tax. We've not made any outrageous assumptions here. We've assumed that the trust grows at 3%, and there's a 5% income rate. If the donors live to life expectancy of 22 years, animal protection would have received over $1,800,000. But over their lifetime of those 22 years, the donors would have received about $1,500,000 of lifetime income. Pretty powerful idea. Again, we'll answer questions if they come up. We had some questions earlier in the audience about life insurance charitable gifts. This one's very easy. You simply transfer an existing life insurance policy to AP&M, or you would direct AP&M to buy a new policy for you, and you would contribute funds every year for AP&M to pay those premiums. The donor receives an immediate income tax deduction based on the policy's fair market value. On a whole life policy, it's roughly equal to the cash value. Let's use a simple example. There's a $100,000 policy. It has a $25,000 cash value. You transfer the $100,000 of death benefit to AP&M, and you get a deduction for the cash value. In this example, it's about $20,000. And AP&M will receive a large sum in the future. Doesn't matter if you're 25 or 35 or 85, the AP&M will be guaranteed to receive that money. It's a tremendous magnification of your gift. I just simply stated a $100,000 policy that you're contributing $2,000 a year for, again, depending upon your age and your health. The premiums each year that you gift to AP&M to pay the premium are tax deductible. You can insure a husband and wife under one policy. You could insure a mother-daughter under one policy. You could insure siblings under one policy. It could be whole life, universal life, or term insurance. They're all eligible. We've done these with same-sex couples. We've done them with people that are they essentially have a long-time partnership, a male and a female with a long-time partnership, but they're unmarried. We can use it for those examples as well. Many years ago, my kids were at Manzano Day School, and we set up a charitable life insurance plan. Myself, some of the other board members, the head of school, some of the other family members, we had a 5-year plan where we each paid in. The minimum was $500 a year for 5 years, and I think the top on it was $5,000 a year for 5 years. And now Manzano Day School has a policy on each of our lives that'll be there in perpetuity. Further thoughts, I want to talk about inherited retirement accounts. I told you that my dad passed away about 6 years ago. I received his IRA, my brother, my sister, and I, and we were allowed to stretch those out over our lifetimes. Well, now that doesn't exist anymore. If you're a non-spouse, those inherited retirement accounts have to be distributed over 10 years. So the whole idea there is for the government to accelerate those distributions and accelerate the taxation on those IRAs. So if you all have IRAs, you name your spouse, or there's certain other categories that can receive those IRAs and stretch them, but it's primarily a spouse. Or if you had a disabled child, he or she could stretch them out. But in general, adult children cannot stretch those inherited IRAs over their lifetime. And it creates a huge income tax. And another item that's come out as part of the most recent acts The trigger age for having to take those required minimum distributions is now extended to age 72. It used to be age 70 and a half. So now you can stretch those out, and you can, pardon me, you can continue to make avoiding distributions until age 72. And we'll see here in a minute that the CARES Act, the CARES Act is many, many, many pages, and there's a lot of other benefits that I don't have time to discuss here. But the CARES Act also said that if you're over 70 and a half, you do not have to take your required distribution for 2020. So a lot of people wanted to avoid those distributions for 2020. One, because their IRAs got plummeted with the market earlier this year, and they didn't want to be taking money out of their IRAs when the market values were so low. So you're not required to take one for 2020. You just need to tell your IRA custodian, your broker, your bank, whoever holds your IRA, that you don't want it for 2020. Also, under the CARES Act, you know, there's a 10% penalty on most retirement plans and 401ks. If you take money before age 59 and a half, there's a 10% tax penalty. Well, that's been waived for COVID-related distributions. Also, they've increased the 401k loan amount up to $100,000 for COVID-related distributions. So previously it was at 50% of your balance up to $50,000. Now it's 100% of your balance up to $100,000. Pretty significant. Also, another feature that's been added is an above-the-line charitable distribution, a charitable deduction for up to $300 for non-itemizers. Earlier, I said that if you're a non-itemizer, remember you've got that big standard deduction, and you want to make a gift to AP&M, you can't get a write-off. But now they've liberalized this to allow you to make up to $300 in an annual gift for 2020, and it's an above-the-line charitable deduction. So it's not an itemized deduction. So that's a very, very nice feature. I believe I've covered everything that I wanted to address, and we've got some time for questions and answers. So Isabel, I will turn it over to you.
Thank you, Mark. That was super, super informative. I learned a lot from both of your presentations, so thank you so much. I do have a couple questions that I received prior to the start of the program, and also just a reminder, if anyone has questions, you can just pop it in the Q&A button, which is down at the bottom of your screen. The first one that I received is, at what age is it appropriate to begin planning for legacy giving? And are there some giving mechanisms that are more appropriate for people who might be in a younger age bracket?
Vicki, would you take the first part of that, and then I'll conclude on it.
Sure, thank you. So in our office, people come in and frequently they'll say, when I ask them why now are they thinking about estate planning? And they'll say, well, I just turned age, fill in the blank. It could be 50, 70, whatever age triggered them to start thinking about estate planning. And we almost always respond, don't you ride in a car in Albuquerque? Because if you do, you probably should think about estate planning documents if you're 18 and are legally authorized to sign a healthcare power of attorney and a HIPAA waiver and the living will that we talked about. So we would argue that you have your estate planning process start. It doesn't have to be complicated. You probably don't need a complicated trust, but you should at least start thinking about estate planning, including your legacy and where you want your assets to go at 18. My children, I have three kids, and 2 of them are older than 18, and both of their birthdays fell on a Saturday, and they were the first appointment the following Monday morning because we wanted to get the HIPAA waiver and the healthcare power of attorney in place for them.
Well, a couple of other ideas for young people for charitable giving. I'll give an example of a young man and his wife who I met in 1999, I think they were probably 32 years old. So now I believe they're in their later 50s now. They had made $1,000 a year commitment to the University of New Mexico, where they both graduated. They made $1,000 a year commitment to Albuquerque Community Foundation, $1,000 a year commitment to the Albuquerque Academy, where they both graduated. And the last $1,000 commitment, I forget which institution it was at this time, but they asked me how could they really make a significant gift with that. Well, each of those organizations, they made a direct gift of $1,000. They went and bought insurance policies covering husband and wife. Collectively, those 4 gifts will create almost $1 million of benefit when they pass away. So it was an easy way for the young people to really magnify their gifts. And it doesn't have to be $1,000 a year. It could be, $250, $500 a year, and it would just determine based on your age and your health how much would go to APNM or APV. So another idea is that the Community Foundation, they all have these donor advised funds. Some of them require $25,000, some are less, but and they allow you to put it in over 5 years usually. So you could make $5,000 a year for 5 years, and now you've created a wonderful legacy. The young people, their parents could actually help them fund this. The parents could gift the kids $5,000 a year to create this fund. A lot of good ideas for young people.
Yeah, those are some super creative ideas. I really appreciate those. And I'm going to be thinking about how we might be able to implement those. My next question from our supporters is, what if I include a charitable organization in my estate plans, and then I find that I need to alter my plans due to unforeseen circumstances?
Vicki, take the first part and I'll finish it up.
Okay, great. So again, I don't mean to sound like a broken record, but it's important to make sure that you have a good team of advisors consulting with you on your estate plan, because you want to be sure that you understand whenever you make a commitment to a charity, if it's disclosed to the charity, you want to understand if it's revocable or not. And typically, most pledges or charitable bequests are items that you can change if you want to down the road. So we talked about your will and your trust. Those are revocable. If you set up a charitable remainder trust, you can you might be able to change the charity depending on how the trust agreement is drafted, but it has to go to charity. That's an irrevocable transfer. And so I would just encourage you, if flexibility is important to you, make sure that that's incorporated in your estate plan when you establish it.
And just a quick add-on to that. If it was a beneficiary designation, let's say on your IRA, your life insurance, your annuity, and let's suppose that you felt your children were all going to be in good shape financially, but there was a change of events. Maybe one of the children has a health issue. Maybe one of the children has lost their job. Maybe one of the children has gone into bankruptcy or something like that, unforeseen. You can always change the beneficiary on those IRAs, life insurance, or annuities.
Yep.
Great. Thank you. That's great to know, I think, for our supporters, many of whom are reevaluating things right now. And my final question is, what options for plan giving are the best when tax deduction is not a concern? As you know, this is particularly pertinent to our supporters because we have a C4 arm, animal protection voters, that many of our supporters want to include in their plan giving.
Well, the life insurance idea would still work, but you just don't get a tax deduction for the premiums. That would certainly work. Any of the direct gift ideas during your lifetime will work. And as Vicki said, bequest in your will or trust would work. Some of the other ones, like the charitable remainder trust, it has to have a charitable beneficiary. It has to be a 501c3. Mm-hmm. But most of the ideas will still work. Vicki?
I generally ask clients to think more about what items they're interested in using to satisfy a bequest. And then when they pick the asset, we can talk about the best vehicle. So it would probably be the same thing if you were making a gift to a 501c4. Think about, or if you weren't worried about the charitable deduction, think about which assets you want to leave to that charity, and then talk to your advisors about the best way and when you're willing to part with them. Is it going to be a gift during your lifetime or a transfer at your death? And then just brainstorm with your advisors about how best to achieve that.
And what I've found, Isabel, is that if people come into my office with the primary idea of saving taxes, it doesn't usually work.
Yeah.
They've got to be passionate about their charities,
Mm-hmm.
and the tax is a secondary consideration. I've got one beautiful case I'll share with you. The woman had a great firm. Her husband was actually her employee. They were both engineers by profession. It was a multi-million-dollar business. They came to me not because of the tax savings, although they were important, but they transferred their entire company into a charitable remainder unit trust. And the buyer for the company, because they were selling the company, the buyer of the company purchased their company from the charitable remainder unit trust. And so now the charitable remainder unit trust has a couple of $1 million in it that is paying out 6.3% to the husband passed away, but it's going to pay out 6.3% to her for the rest of her life. And so she's getting like $120,000 a year for the rest of her life. So a win-win. She won from tax purposes. She gets income for her lifetime. And the University of Arizona, where she and her husband got their doctorates from, is going to receive probably $3 million when they passed away. She's still a pretty young woman. She's barely 60. So some beautiful ideas you can sell. I'll just give you one other short one. I'm sorry to take too much time on this. The guy sold his insurance agency. He was a board member of the Santa Fe Opera. He sold his insurance agency through the Charitable Remainder Trust. And ultimately, when he passed away, the Santa Fe Opera received $500,000. But he got income for life.
Wow.
So some beautiful ideas there. It's beyond this. We've run out of time, Isabel. But you know, if people direct their questions back to you or Vicki or me, we'll be happy to answer them. But I think Isabel would be your best way to place those questions. Vicki, Isabel, anything further?
Thank you, everybody.
Yeah, thank you all so much. And those are some really creative ideas from you both. We're just so appreciative. So thank you, Vicki and Mark, and thank you to everyone who attended. We really appreciate your time today.
Thank you, Isabel.
Bye, everyone.